In this lecture, we will see the cyber laws, cyber crimes, and some case studies that are dealing with the penetration testing or ethical hacking. So in the last lecture, we have seen the general overview of the IT Act and IT Amendment Act, and we have discussed some specific chapters of the IT Act and IT Amendment Act, and also we have seen how or what are the new things that were added or amended in the IT Amendment Act 2008 while comparing with the IT Act 2000. Anyhow, we are always supposed to quote the recent one. So IT Amendment Act 2008 will be quoted, in which already the IT Act 2000 will also be included. Today, we are going to see the cyber laws, cyber security, and some case studies that are pertaining to the penetration testing. Cyber laws for cyber security. Basically, under the IT Act 2000, from section 70 to 74, these sections are dedicated for the cyber laws. Section 70 deals with the unauthorized access to the protected system. Section 71 deals with the misrepresentation to the controller or certifying authority. Section 72 deals with the branch of confidentiality and privacy. Section 72A deals with the disclosure of information in branch of contract. Section 73 and 74 deals with the publishing false digital certificates or digital signature certificates. Basically, this cyber security or cyber crimes can be classified into three categories. The first one is crime against individual. Second one is crime against an organization or a property. Third one is crime against nation. So we are going to see the three categories in this lecture. The reason is, as a penetration tester, maybe because of the ignorance of the penetration tester, there may be a damage may happen to a individual's resource or maybe a property. The property may belong to any organization, or maybe sometimes it may belong to the government also. So that is the reason these three categories are very important for us to discuss. Here, the crime against individual. The crime against individuals are classified into three categories. Here, stalking, the web jogging, and cyber defamation. So the stalking is also said to be cyber stalking. Cyber stalking involves repeatedly following a person, harassing over phone calls, and with written messages, and threatening either the individual or his or her family using the internet, email, or electronic communication devices. It is punishable offence under section 503 of IPC and also section 506 of IPC. If the messages are of threatening nature, then otherwise under defamatory case or under defamatory section, the things are punishable under the section 499 and 500 of IPC. That means the stalking is of threatening or harassing, then IPC 503 and 506 will come into the picture. If it is of defamatory, then section 499 and 500 of IPC will be coming into the picture. And this is punishable since they have made this particular stalking or harassment or any kind of this what you call defamation. Then since they are using the electronic communication devices, so whenever the electronic communication device come into the picture, then obviously under the defamation and threatening, the section 66 of IT Amendment Act 2008 will come into picture. Next one is webjacking. Webjacking is the way of hijacking the web. This is a sort of crime involves the perpetrators forcefully taking the control of a website by cracking the administrative privileges, so that actual owner of the website has no more control over it. In such cases, this webjacking case may be registered against the hacker, or if he is a penetration tester, then this particular webjacking may also be filed on the penetration tester, and it is punishable under Section 65 of IT Amendment Act 2008 and the IPC 383, Section 383 can also be filed under this particular crime. Next one is cyber defamation. Cyber defamation is referring to the or is nothing but publishing offensive content against an individual with the intent to spoil the reputation and modesty of a woman, or with the use of that is with the help of internet, then it is said to be cyber defamation, and it is punishable under the Section 66 of IT Act 2008 and Section 500 and 509 of IPC. So this is what they called. These are the crimes that is generally happening in the society or in the internet world for crime against the individual. So this is what the crime against individual category. Next, we will move on to the crime against the property. Here, there are the sections which are useful for booking under the crime against property. Here, first one is identity theft. Identity theft is nothing but stealing of the identity credentials. That means usernames, passwords, these kind of things. Either this identity theft may be done via forgery also. So forgery will also come into the picture. Here, electronic forgery or digital forgery may also come into the picture. If it is done so, then IT Act 2008 under Section 66C, they can be registered, they can be booked, and for this the punishment will be done. Punishment will be imposed based upon the IPC Section 417A and 420. So 420 is the cheating case, and 417A is what you call stealing of the credentials or stealing of the identity or creating the fake identity. So these are the sections under which this identity theft will be dealt. And in this identity theft, not only individual usernames or something, but also sometimes password theft. So the password may be theft physically, or maybe via cracking the passwords, or in any other form. The identity or password was stolen. Then this identity theft can be registered. Next one is email spoofing. Email spoofing is nothing but spoofing of the emails. So email spoofing, actually what will happen is here spoofing of the customer emails of a particular organization or a bank or any kind of organizational network or financial institutions or anywhere where the general commerce activity will happen. So these all things will come under the email spoofing. Here, this will be punishable offense under the IT Amendment Act 2008, Section 66D. And for this, the linking IPC sections are 416, 417, 463, 465, and 420 of IPC. Next, we'll see the data diddling. So, data diddling refers to the attempt to made towards illegal and unauthorized alteration of the data. So it is punishable under Section 43 of Section 43 and 65 of IT Amendment Act 2008. Next one is email bombing. Email bombing in the sense sending enormous number of emails to the victim's network or to victim's personal computer or victim's personal email ID with the intent of causing the damage to the server or damage to the system, especially the damage is related to the denial of service or maybe the what you call the setting of the system or maybe overflowing of the emails into the email server. This kind of things will come under the email bombing. So it refers to sending an enormous amount of email messages, threatening a server with the intention to crash it. This crashing may be done via conducting the denial of service attack. So if such kind of things were happened, then IT Amendment Act 2008, Section 66 will come into the picture, and the culprit may be booked under this case. Next one is financial crimes. Obviously, the financial crimes in general will happen targeting the financial institutions such as banking and electronic commerce websites where the financial transactions are involved. So any such things will happen, then the IPC section 415, 384, 506 and 511 will come into the picture to book the culprit. Next one is salami attack. Salami attack is nothing but the hacker will not conduct a violent attack at a time. However, he will do the small attacks. That small attacks may be negligible, but they will leak some important information about the network. This is called salami attack. In the general military operations, this is also called as salami slicing. Usually, the enemy countries used to occupy some small portion of the another countries. Okay, so whenever the small portion of the other countries are occupied, then there will be a standoff will be there between the countries, but the standoff cannot be a long time, and sometimes the weaker countries among these two may leave up the space and will look for their regular works. So like that, after a certain time, the one who is performing salami attack or salami slicing will occupy some more space in the other country. Like that, they keep on occupying the small places or small distance places, maybe of 3 kilometers, 4 kilometers, which will be negligible, but which is very important. But over a period of time, what will happen? If you look at for every year, if they can occupy 2 kilometers over a 50 years, then around 100 to 150 kilometers they can easily occupy and can form a village or some several villages. That is what the strategy of China today in the world. So they simply occupied the Aksai and the Pangwan Lake near India border. So the one who have not recognized it might have left it and they have occupied it. But when the governments are strong, then they are protesting and they are making a standoff at that level. So till they leave that particular place. So this is what the salami attack and salami slicing in case of the military operations, where in case of cyber security, this is also called as salami attack. However, here the attacker will perform small attacks which will be treated as a negligible but will relieve lot of useful information. So this kind of thing is said to be salami attack, and it will be fall under the IT Amendment Act 2008, Section 66. Next one is cyber fraud. Cyber fraud is nothing but sending of lottery mails or any other enthusiastic mails by saying that you deposit this much amount and you will be getting the remaining amount. So usually these Nigerian country people used to do all these kind of things. They are very famous in doing this kind of cyber frauds in the entire world that you might have read in the newspapers and many other places. So this is what we call cyber fraud. This cyber fraud can be booked under section IPC section 420. Then denial of service attack, the email bombing or maybe any form of the denial of service, either maybe buffer overflows, exploiting of the vulnerabilities, or maybe via the hardware, any kind of thing, jamming and all these kind of things will fall under the denial of service attack. So in the general military operations, blocking of roads will also come under the denial of service attack. Okay, so in the real world, the blocking of roads should not be done. In general, blocking of any highways will be considered as the act of war. So, but I don't know how many of the governments are taking it seriously. But according to the international laws, blocking of roads will be considered as an act of war. So government can take any action on this. In the same way, in the denial of service attack also, this is nothing but denial of service. That means you cannot, no one can go from one place to other place. Simply you are blocking that particular road. So the general public has to face a lot of things than the one who are protesting on the roads. So in the same way here, the denial of service is nothing but a blocking of certain routers, blocking of certain small network devices which are on, in the what you call in the communication channel. So whenever this kind of small blockages were occurred, automatically what will happen? The flow of traffic will not be sufficient to pass through that particular network devices. Automatically, packets will be dropped. So it is just like having a small blockage in the heart blood veins. So where even a small blockage was occurred, then it will cause a serious damage. Okay. In the same way here also, in the computer networks, in the communication channels, especially if this kind of blockage was occurred in any of the network devices, automatically that particular traffic cannot be passed through that particular devices, thereby the packets may be dropped. If it is a UDP communication, no retransmission will take place. But if TCP communication is there, so many retransmissions will happen. Whenever the so many number of retransmissions will happen, obviously it increases the traffic on the network channel. Thereby, instead of dropping the packets, the network devices cannot do any other thing as there exists a blockage. Thereby, it is leading into the denial of service attack. So, this kind of operations we have seen in the lectures of denial of service. What are the different ways we can cause a denial of service attack? So, this can be booked under IT Amendment Act 2008 under Section 43. Next one is hacking. Hacking is the general activity that will be carried out by the most of the experienced hackers, where you are going to capture the networks or network resources, and thereby it may lead to several other serious attacks. If this kind of things were happened, then it will be booked under the IT Amendment Act 2008, Section 66 and 43. And for this linked sections under IPCR 378, 379, 405, and 406. Next is planting of viral or worm attacks. So planting of viruses, worms like WannaCry attack and ransomware attack. So these are the viruses that will be injected or trojans that will be injected into the victim's network. Thereby, that will be spreaded throughout the network whenever the network operations will happen. So thereby, what will happen in case of ransomware attack? All the files and data which are available on the disks will be encrypted, and to decrypt that, the hackers will ask for some ransom. Then, whenever the ransom was paid, then only it will be released. So, this kind of operations will be happened in the ransomware attack. So, this kind of virus or worms injection will be falling under IT Amendment Act 2008, Section 43 and 66. While coming to the logic bomb in the sense identifying the weakness in the logic of the application by looking at by exploiting the logic which is available in the application, the exploitation may be planned, and this kind of things will fall under the logic bomb. So IT Amendment Act 2008 and Section 43 and 66 will come under this logic bomb. Next one is forgery. You are all aware of that forgery in the sense here the keeping of fake signatures. In case of the digital platforms, this forgery will comes under the may form under forging of the digital signatures and uh, forging of the general electronic signatures. These and all will come under the forgery, and forgery can be booked under the IPC section 463, 465, 470, and 471. So these are the various crimes against the property, and these are the various corresponding IT Amendment Act sections that in which the person may be or the culprit may be booked. And sometimes along with this crime against property, there are some other crimes will also be possible, like copyright stealing, or making of fake copyrights, or any copyrighted material maybe downloaded, or maybe duplicated, which is also called as piracy. So these kind of things will also come under the IT Amendment Act, and they can be booked under the sections 51 of IPC. So these are the crimes against property. Now we'll move on to the crime against nation. So this is a third level or third category under the crimes. Here the main things are like web cyber terrorism, Section 66F of IT Amendment Act 2008, Section 153A of IPC, and UAPA 15. UAPA means um, Unlawful Activities Prevention Act. Okay. Uh, so this is Section 15 of UAPA will come under the cyber terrorism. So this cyber terrorism especially uh, will be happened by especially to disturb the peace and harmony in the country, and also to disturb the all linked servers of the country. So there may be several government side servers which are interlinked. So this interlinking can be broken. The attacker wants to break this particular interlinking, or may want to create the denial of service on the particular server. So these kind of things can be considered as cyber terrorism. So cyber terrorism is the crime that is committed in the cyberspace, especially disruptive activities that targets social, religious, and political beliefs, thereby spoiling the peace and well-being of the society, a community, or a nation, or maybe at the uh, government level. So this cyber terrorism is punishable under, as we have seen in the slide, that it is punishable under Section 66F of IT Amendment Act 2008. Next one is pornography. So in this pornography is publishing of the obscene material which is related to the sex, and at the same time which is related to the child pornography. So these are the things will come under the pornography. So Section 67 and 67B of IT Amendment Act 2008, and Sections 292, 293, and 294 of IPC. So this kind of things will come under the pornography. Next one is website defacement. So website defacement is nothing but the web defacement that we have seen in the crime against individual. The same thing you can also consider here. That is replacing of the web pages, placing of absence content on the web pages by the enemy countries, or the hackers who are sitting in the enemy countries, will be falling under the website defacement. Here, Section 65 of IT Amendment Act 2008, Section 463, 464, 468, and 469 of IPC will come into the picture. So these are the crimes against the nations. We'll see some case studies. So here, before attending these case studies, let will answer. Let will recall the keywords like cyber defamation, cyber stalking, cyber terrorism, data diddling, email bombing, email spoofing, logic bomb. So these are the terminologies that you must remember, as these are the most commonly used terminologies in the IT Act and IT Amendment Act. So to answer this particular case studies, or to solve these case studies, first of all, you should know these general terminologies. Then recall the sections applicable under the IT Act 2000, IT Amendment Act 2008. Actually, the sections like 43, 44, and 45. Then section 65 to 70 and 70 to 78, 74, which will come under the cyber security, cyber laws. Next, identify and describe the cyber laws in India under which the culprits of the following cases can be prosecuted. This is the third question, which is a very important question for understanding the case studies. In a renowned company, The accounts executive was alleged of changing the employee's timesheet information before that the data was entered into the payroll application. This resulted in paying more than what the employee worked for and a huge revenue loss for the company. In other incident, one of the employees of the company allegedly altered the presentation of his colleague with junk data with the intent to harm him, as he was jealous about him. This led to a situation where the colleague was expelled from the company. So in the first case, what happened? There is an accounts executive. He allegedly changed the employee's timesheet. Usually, there will be payment or remuneration based upon the time number of hours employee worked. So, but what he did is he allegedly changed the timesheet. That means even though the employee worked for 5 hours or 6 hours, he made the employees that some of the employees to work for around 8 hours or 9 hours per day. So additional hours they have worked, so hence additional amount has to be paid. So all after observing all things, they identified that this is the tampering was done. So this will fall under which category? This will be falling under the data diddling. Data diddling is the tampering of the data, and under the data diddling, the related sections we have seen previously. What are the sections? Here the sections are IT Amendment Act 2008 and Section 65 and 63, sorry, 43. So these two will come under this particular data diddling, and any other cheating or fraud case like IPC 420 also can be filed under this particular category. Next one is because of the jealous on another colleague, one employee what he did is he placed junk data in the presentation of other colleague. So it is especially to intend to harm him. So because of that presentation, because of that junk data in the presentation, obviously that company that employee was expelled from the company because of the wrong presentation. So this is also this can also be comes under the data diddling case because he tampered the data. At the same time, he lost the job because of that particular. So he may be booked under the IT Amendment Act 2008, Section 65 and Section 43. Next one is in 2001, in the backdrop of the downturn in US-China relationship. So wherever you go, this thing will follow. Okay, China will always follow in this. So in 2001, in the backdrop of the downturn in US-China relationship, Chinese hackers released the code Red virus into the wild. This virus infected millions of computers around the world and then used those computers to launch the denial of service attack on US websites, prominently the website of the White House. Now you can understand this particular thing can be fall under the crime against nation. So which is also called as cyber terrorism. So this is a kind of cyber terrorism that they have done, and since that particular activity, if they might have launched the activity from the outside of the country, then it will fall under cyber terrorism, and all these sections will come into the picture. Section 66F of IT Amendment Act 2008. This is with respect to the Indian laws. In US there may be several federal laws that may be different, but if the same operation or if the same kind of thing was happened, we should not expect that this should happen. But if something was happened like this, then under the Indian laws, so we can count it as Section 66F of IT Amendment Act 2008, Section 153A of IPC, and UAPA 15. Here, the causing is the result of this is denial of service, and since the injection of the code red virus, so under the crime against the property, they can also book under the viral or worm attack, that is IT Amendment Act 2008, Section 43, 46, 66, and denial of service attack, IT Amendment Act 2008 and Section 43. So these are the various sections that can be applicable under this particular case. Next case we look at Berhampur City Hospital in Odisha, Ganjam district fell prey to WannaCry virus and ransomware attack in May 2017. The system in the hospital were managed by the National Informatics Center. The viral attack has encrypted the data of e-Aushadhi portal and hospital information management system. The alleged hacker had demanded the payment of ransom of rupees $300 to restore the old files if the system and the warning that the data in the system would be destroyed. So to restore the old files, they have asked for $300 for one file, and they have warned that if you have not paid this much amount, then the data will be destroyed if there had been delay in the payment. This is the real problem that was found in the Berhampur city in Odisha. So this was happened in May 2017. So basically, this is the WannaCry virus. So whenever the culprit was found, if the culprit was found and identified, he may be booked under which cases. So that particular hacker can be booked under the cases because they have installed the viruses. So viruses and worms, IT Amendment Act 2008 and Section 4366, and they can also be booked under the IPC under the threatening cases because he is threatening the hospital that if there exists a payment in delay, then he will destroy the files or data. So this is one example case. Next, let us see another example case. A software professional from Bangalore was booked for stealing of a product being developed by his employers. So this is the copyright issue actually. He started his own company and illegally used the source code to launch a new software product. Okay, so this is mostly you might have seen in the newspapers also that a software professional who is a very brilliant person who worked in a company and he know what are the coding and what are the things they have used because he is maybe at the architect level or maybe designer level. He know what is the design of that thing, and because of the remuneration distances or something or disputes, he might have left the company and he has started his own company, but he might have used the old design that was used in the previous company in his own company, but the previous company might suit a lawsuit like that he has stolen that design and all. So this is also obviously if they might have done in a digital way, that means designing or what call stealing or the copying of the same design of the software or maybe any other thing, then it will be fall under this particular under which form or under which act of the IT Amendment Act it will fall. That means it will be falling under the copyright protection. Okay, it will be falling under the copyright laws. So the same was happened in 2001 between the Sun Microsystems and Microsoft. So the Microsoft has claimed that C# is the pure object-oriented language. No other language in the world is having these features, that is object-oriented features. But if you look at C#, it will look similarly like Java programming. Okay, so the Sun Microsystems have suited the Microsoft that they have stolen the ideas of Java Java software and Java runtime environment, and they have developed the same code structure like Java programming. Finally, the Sun Microsystem has won the case, and some millions of dollars the Microsoft is supposed to pay the Sun Microsystems. This is what the example of copyright stealing, and this is a very dangerous thing nowadays. This will be mostly happening. That is the reason always whenever you find you are doing some new activity or something, you must copyright it or you must transfer the copyrights. Okay, with the help of the one who have done this have to sign that particular agreement, or there should be some normal agreement must be there that this particular content can be used by so and so, like that. Next one is the final case that we'll see now. Mahesh and Anand were arrested in 2002 for illegally changing the homepage of Mumbai Cyber Crime Cell. They had illegally used the password cracking software to crack the FTP password for the police website. They can they then replace the homepage of the website with obscene content. They both are charged with the credit card fraud of using 225 credit card numbers belonging to the American citizens. So in the first case, what will happen? What happened? They have done the password cracking. Okay, password cracking is nothing but identity theft. It may be user ID and passwords. This particular section, IPC section 417A and 420 under section IT Act 2008 section 66A can also be booked under this. Next one is they have replaced the home page of the website with some obscene content. So it will fall under the website defacement. It will fall under the website defacement, and these are the sections that can be booked under this. Next, what they did is then they replace the home page. Okay, then they both are charged with the credit card fraud. That means here credit card data stealing. So this is also called identity stealing or data stealing. And in this fraud, if they might have fabricated a new credit cards with the duplicate credit card numbers, then they can be booked under the forgery. At the same time, they can also be booked under the data diddling. So these are the various acts that can be charged under this particular case. So here, these are things you may find it as a normal cybercrime, but actually here password cracking. Who will do this password cracking? Unless until they don't have the technical knowledge and networking knowledge or hacking knowledge. So at the same time, in this previous case, who can inject the virus? They cannot directly inject the virus, right? They have to go into the network of the computer, and there you are supposed to place the virus, as we have seen in the system hacking. And at the same time, who will do this particular placing of the code red virus into the US network? So this will be done by the hackers only. Next one is here. This data employees, because they are the internal to the company, this here the accounts executive or this person can do this. But here section case study B, C, and E, these three can be done by the externals. So these are the three things can be done only by the hackers. But if, as a penetration tester, if you might have if you might have done the network testing, then if you might have not left, or if you might have not closed the traces or covered the tracks, then it may exploited by the hackers. So thereby, even though you are a legal penetration tester or ethically you did, because of the unclearing of the tracks, it may be exposed to the hackers. The result of the hacking may fall on you people, that is ethical hackers. So that is the reason these are the laws that you must be aware of before moving on to the penetration testing. And some other things are like this: study following Indian cyber law cases, 20th Century Fox Film Corporation versus NRI Film Associates, that is a copyright case. Next one is struck down of section 66A, which is freedom of speech, which was given under the Article 19 of the Indian Constitution. So it is against this particular IT Act. This Article 19 of the Indian Constitution. So this section 66A was struck up by the Supreme Court. So you can see the case details and all in this particular link. And recently also, the Supreme Court and many of the high courts of the India was charged the Twitter and Facebook social media for circulating the fake content or this kind of heated arguments by the subscribers. So they have asked the center for the opinion, and center said that this is the freedom of speech unless until they don't cross the limit. So it is we don't have any objection of using the social media for expressing their opinions, but the opinions must be bounded to the law. So that means you can use the social media for expressing your opinions, but you should not perform any kind of defamation or degrading comments or any other thing. You can express your opinion, but here no degradation of the or no defamation should be done, and there should not be damage to the personal things or person or any organization. Without that, you can express anything, as the center told the Supreme Court around 2 days back. So that means they are with the Constitution of India, that is Article 19 of the Constitution. So it is against that. So this section 66A was struck up. Next one is electronic record as evidence. Here, this is the case of the state of Maharashtra versus Dr. Praful B. Desai. This case, you can see that where the electronic records were produced as the evidence for the first time, and the court has accepted the as electronic records as evidence, and thereby under the Evidence Act, some amendments might have done. Those amendments we'll discuss afterwards. So that means what are the electronic records that can be considered as the evidence. So these are the case studies that you can go through that afterwards. And this particular case studies and tutorial is also available in the Google Classroom. You may access them. Next here, these are the summary of the cyber laws in India. You can go through this. Already we have discussed all these cyber crimes and cyber laws. So these are the summary of the cyber laws and under which section this can be punished, and for sending the threatening mails, defamatory mails, messages, bogus web mails, email spoofing, webjacking, email abuse. So all these things, what are the all these cyber crimes and what are the related IPC sections that we have seen. Next is these are the amendments that have done in the Indian Evidence Act, because we have seen here the last one, that is considering the electronic records as evidence. So by keeping it in mind because of the electronic communication devices, section 22A, oral admission as the content of electronic records, section 39 was modified. Section 47A, opinion as to electronic signature, that can also be that is also accepted. 65 section 65 Special Provision Act relating to the electronic records were modified, and section 73A, proof as to verification of the digital signature, was included. Section 81A, presumption as to gazettes in the electronic form. That is the reason you will see all the GOs in the electronic form in the government websites. This will be possible because of the section 81 addition. Next is 85A, presumption as to draw an inference as to conclusion of the argument in electronic form. So that is the reason nowadays you are finding the court verdicts over the internet. Next is section 88A, presumption as to genuineness of the electronic records of 5 years, which is produced for the proper custody. So under the custody, at least 5 years of the past data must be available. So this is the thing that was mentioned. In the around 3 months back, the government, the Supreme Court has also amended this as sending of the notices via WhatsApp or any other social media is also accepted. So these are the various evidence acts that was modified because in view of the use of the electronic devices. Now we'll see the penetration testing by letter of the law. Always, whenever you are agreeing for the penetration testing, you are directed to make the letter of the law. Otherwise, you will be falling under the legal obligations. For example, here the territory bound legislation. Different states have different security regulations. Imagine that the customer is in Texan company that wants to test the network of their Kansas branch, and the penetration tester is working from his own office in Colorado. That means company is in one place and he wants to test the network in some other branch of the same company, but the penetration tester is in the Colorado. So these are 3 different states, and how a penetration tester can approach the legal thing. That means he must have the legal permission from both these 3 states. Otherwise, he cannot proceed further. And it is the responsibility of the organization who is hiring the penetration tester to make a legal agreement. The customer and penetration testing provider should both remember to clear the issue out before signing the contract. This particular legal issue must be cleared because it is involved in 3 different states. This is also very important. You may be sitting in Bangalore and you may want to perform the penetration testing of a branch which is available in Germany or any other place. Obviously, you have to clear the laws, or you have to clear the issues of legal things in both countries. Then only you have to perform the penetration testing. Next one is the get out of jail free statement. The making of the legal agreement is a kind of get out of jail free statement. is a document that the customer should give to the penetration tester to prove that penetration testing is permitted. So I am legally permitting to do this penetration testing. So and that the customer is authorized to give this permission. There is no unified get out of jail free statement to fill in, but usually it begins with the explanation of the reasons for testing followed by the penetration testers and the customer name and signature. So it is just like a contract or a legal contract. Scope of the work is must to define. We'll see why this particular scope of the work is very important. High on the agenda, regardless of the penetration testing type, is the necessity to specify the scope of work. As a penetration tester, you must ask the organization what is the scope of work. The scope of work must be clearly defined, like this includes the amount of networks, the range of IP addresses within one network, subnets, and computers. That means what are the IP ranges to be tested, what are the subnets to be tested, and what are the computers to be tested. Only those specified IPs, computers, subnets must be tested by the penetration tester. And also, this scope of work should include what not to be tested, not only which to be tested and what not to be tested. And don't touch the router, and don't touch this one, and don't touch that one. So should be clearly mentioned in the legal document. If it is not mentioned, then sometimes because of knowingly or unknowingly, you may explore some other things which is not related to the organization. Let us examine the cases. Case 1. Customer Tom Limited had gone through the penetration testing, and shortly after the company got hacked. So they have the company, Customer Tom Limited company, has gone for the penetration testing, and the penetration tester has given that there is no problem, absolutely correct, excellent. But shortly after that, after 1 week, the company got hacked. They made a claim on the penetration testing provider for the quality of the service he provided. That means here the customer was certified by the penetration tester for meeting certain security standard, but when in fact they don't. So that means the penetration tester has given the certificate that you are meeting the security standard, but after 1 week, what happened? The company's server was hacked. So obviously the company will file a legal suit to claim the amount from the penetration tester. In turned out of that Tom Limited did not include the scope of work several systems that were hooked to the internet after the penetration testing has already begun. As a result, those systems were left unattended, and it becomes a target for the hackers. That means because of the lack of scope of work mentioned and with the legal document, the penetration tester simply looked around the network here and there, but some of the networks or some of the devices were connected to the internet. Because of the exploration by the penetration tester, those ports were turned on, or those ports were opened, and those ports which are opened and linked with the internet have become the target for the hackers. Thereby, the hackers entered into that system with that ports, open ports. That we usually check for the open ports using Nmap and all. We have seen in the penetration testing activity. So in the same way, the hackers will also look for the open ports. Unfortunately, this penetration tester have opened the ports which are on the devices which are linked with the internet. They have made the entry point for the hackers to enter into the computer of the organization or net company. Thereby, the company servers were hacked. So this is because of the lack of the scope of work, this thing will happen. Next one is Customer Jerry Limited is a mobile operator that also provides mobile TV services to a third-party organization. This organization contributes all the necessary hardware and software, while Jerry Limited provides its domain name. During the penetration testing of the Jerry Limited network, penetration tester hacked a server of the third-party organization because they don't know that the network is shared resource. So it is quite common that 2 or 3 organizations may share the common resource. For example, our university is there, JP Infotech and JP University, and some other thing may form a alliance, may form as an alliance, and they may form a common shared resource. Shortly, the affected organization filed a lawsuit against the both the customers and penetration testing providers. So that means in the scope of the work, you should also clearly mention who are the third parties and who are the third party countries and who are the other laws, and all the things were clearly mentioned in this. Then only the work has to start. Scope of the work in the cloud penetration testing, because these are the things which are mainly possible in the shared resources, especially the cloud computing is involved. So as an engineer, as a software engineer, you should sometimes work in the cloud environment as an infrastructure as service, or software as service, as platform as service, where there exists a shared resource. So you must clearly mention which cloud to be targeted and which service to be targeted in the scope of work. Next one is notification to the third parties. Obviously, whenever the third parties are involved in the penetration testing, the hiring organization must inform all his third parties that we are going to perform the penetration testing like this. Then please turn off your servers for some time, or do you want to go for security testing of any other product of your linked devices or linked networks? So these are things clearly mentioned to the third parties. So this is what the thing that must be done by the penetration tester. And finally, hacking should be legal and ethical. So legal issues is something that penetration testing providers and customers deal with in every project. If disregarded, they may render penetration testing ineffective or damage the customers and the penetration testing providers' reputation. The list of legal issues described above includes the cases which are easily solvable if addressed in time. Keep them in mind to conduct the penetration testing by the letter of the law. So this is what as a penetration tester, you must define the scope clearly, and you must mention what are the things to be tested and what things should not be tested. So this particular lecture has given you the information about the cyber laws, cyber crimes, and some case studies. As a penetration tester, what are the things that you must take care of?